So now it's my pleasure to introduce our speaker, who comes to us from New York City. And I'm really thrilled that he's agreed to join us, traveling all the way here to Rochester. So Matthew Chachère is someone I've worked with for quite a while and has such an impressive and important role in lead poisoning prevention, both in New York City and the state and many other areas, that it is impossible to do it justice in a short introduction. So personally, I want to share a couple of reasons why I'm particularly excited he's joining us today. So, you know, he's a staff attorney at the Northern Manhattan Improvement Corporation Legal Services. He's been involved in law reform efforts for lead poisoning prevention for over 25 years. Particularly importantly, representing tenants who have suffered lead poisoning and organizations in litigation around enforcing local, state, and federal prevention laws in state and local courts. And as we know, that's such an important role. He's author of many lead-related articles and reports ranging from this comprehensive and regularly updated tome. It's like 150 pages on the lead laws of both New York City and the state. And that document has trained generations of public interest attorneys coming through his office and using the law to protect children from lead. And many shorter things too, including this 2019 article in the New York Environmental Lawyer called Lead Laws, Environmental Justice in New York, which really sets the stage for where we are today. He's also, most importantly, written, amended, or contributed to reams of groundbreaking local and state legislation in New York, including the 3 bills that I think you'll hear about from him today. On a personal note, I've known Matthew for nearly all of the 20 years I've been involved in lead in New York. He was a member of the former New York State Coalition to End Lead Poisoning, working closely with Rochester Coalition members, including the great Mike Hanley and other state leaders, to draft and promote state legislation for decades, including the current lead poisoning prevention law in New York City, which is Local Law 1 from 2004. So his work's been based in New York City, but he's always taken a statewide view. So for example, he has patiently, persistently, and with great vigor contributed to the New York State Advisory Council on Lead for decades. And I have to say, Matthew and I have not always agreed on how to use legal tools to prevent lead poisoning in New York, but his dedication, his vision, his persistence and tenacity on behalf of all of New York's children has won my deepest respect and admiration. It's been a real pleasure to see his brilliant mind and legal skills in action, particularly over the last 2 years as we've worked together on 3 particularly important state bills he'll be sharing with you. I also want to proactively congratulate Matthew on his upcoming, promised retirement. He will be greatly missed and will leave a giant hole in New York's lead prevention community. But there is a lot of work that needs to be done before he can do that. So I'm very grateful he agreed to join us as our keynote speaker this year to share some of the highlights of his work, what lies before us now. Thank you, Matthew.
Well, I'm blushing, but thank you. Can you all hear me?
Yes.
Hello?
Yes.
Okay, good. Good.
We
I'm
could
going to
unmute
share my.
we can hear you.
I'm going to share my screen, and hopefully this is going to work. Sorry, a little tech issue here. Good. Okay. So quick little history lesson here. Oh, and this is not showing up. So let's try this in a different way. I'm sorry. Share screen. Let's try this screen. All right.
While Matthew's queuing up his slides, I just want to remind folks that you can type your questions for Matthew in the chat, and we'll make sure to get them to him while questions and answers are taking place.
Here we go. Okay.
We can see your screen now, Matt. So
yes.
It starts with a little history, correct?
Yes. That's
yes.
Right. Okay. So I'm not quite sure why this is not working properly.
It's perfect now.
Okay, good. Okay. So 50 years ago, New York State enacted what's called Title 10 of the public health law, with some very lofty language. The occurrence of lead poisoning is a major public health concern. It is estimated there are hundreds of thousands of lead poisoned children. The disease of lead poisoning is the most prevalent in areas of old and deteriorating housing So we identified housing is the key issue, right? Where leaded paint and plaster in peeling condition is accessible for ingestion. Lead poisoning is a disease that will require the concerted efforts of public health agencies and other agencies concerned with the availability of healthful housing before it can be brought under control. 50 odd years ago. And we're still talking about this today. So, and we also knew 50 years ago, it's really about housing. So what New York did, it banned the application of lead paint in dwelling interiors and porches, childcare centers, kindergartens, banned the sale of lead painted toys, furniture, granted the health commissioner the power, but not the mandate to, I'm sorry. Why is this? Okay. To declare areas of housing to have conditions conducive to lead poisoning as high risk, and the power, but not the mandate, to order the removal of dangerous lead conditions. Having said that, the courts ultimately, back in the 70s, after some litigation by activists in Albany, they first sued to say, okay, there's this great law, so landlord, you have to correct the lead hazards. And the court said, nope, only the health commissioner can order that. So then they sued the health commissioner to say, all right, you got to declare these are high risk areas and mandate inspections. And the court said, sorry, that's totally discretionary. So the law looked great, but it did very little about housing conditions. In 1992, New York enacted this next slide is showing up, correct? Yes? Good.
Yes, it
okay,
did.
thank you. I have two screens and it's just acting weird today. Apologies. The Lead Poisoning Prevention Act, which amended Title 10, so 20 years later from the first one, they're still saying the same thing. Lead is still the #1 environmental poison for children. Lead is still one of the most prevalent and preventable childhood health problems, but we still have this big problem. Little progress has been made in limiting childhood exposure to paint from interior and exteriors of older housing. So again, we know what the problem is. It's lead paint mostly in housing. So those amendments in 1992 mandated the screening that was being discussed earlier of children, but not mandated the screening of housing. So it was still a secondary prevention law. I mean, albeit one of the strongest screening laws in the country, but still nothing about screening housing. Mandatory reporting of elevated blood lead levels and the referral of those levels to local health departments. In 2007, there were some amendments to start coming up with these pilot programs in high-risk areas. This was actually an idea propounded by our colleague Mike Hanley from Rochester back then. It was amended in 2019 to lower the definition of elevated blood lead level to 5. But still, we have no primary prevention law in New York, astonishingly. There's still no right to a tenant living in, say, Utica to have housing that's free of lead hazards. There's still no mechanism on a state level for tenants to get inspections before their children have elevated blood lead levels. There's still no private right of action for tenants to go to court and say, judge, make the landlord make my home safe. So that's where we still are 50 odd years after the first law. The advocacy on a state level on this, and as Katrina was mentioning, there was a coalition to end lead poisoning in the first decade of this century. At about the same time, the state issued a plan to eliminate lead poisoning in New York by 2010, which still hasn't happened. And guess what? Again, potential biggest source is older housing. We need to have code regulations on housing. So, this is all we do is we keep going round and round saying we need to do something about housing. In 2006, the coalition organized a symposium of a broad array of stakeholders, policymakers, parents, advocates, and so forth at Albany Law School, which came to the same conclusion. And out of that, the advocates put together a comprehensive lead poisoning bill, which called the Perkins Peoples Bill. And I think it was the first attempt at ever framing a primary prevention law in New York. And that was put together by a number of advocates from Rochester, like Mike Hanley and Brian Hetherington and others, and myself and some folks from Albany. And the idea was to have a set of lead hazard controls that would be mandated, create some funding, provide for inspections, require a state registry on unsafe housing. That law went absolutely nowhere. It just gets reintroduced every new session of the legislature. And in 2019, a new group of advocates was formed called Lead Free Kids New York. And Lead Free Kids New York has been pushing for the idea the coalition came up with is, let's see if we can take out some of the pieces of the comprehensive bill that we put together in 2007 and see if we can put it into bite-sized pieces, and maybe we can kind of spoon-fed it through the legislature. So I'm going to talk about 3 of those, and I'll mention a couple of other bills that have been moving this past year. So the first one is what we call the point of sale bill. Senator Kavanaugh from New York and Assembly Member John Rivera from the Buffalo area. And the idea of this bill would be to kind of leverage the federal lead disclosure law, which, as you may know, but if you don't, I'll quickly explain it. There was a federal law passed in the 90s that basically mandates that in any real estate transaction, whether it's the sale or lease of residential real property, the seller or the lessor has to disclose everything they know about lead in the building, including any reports and so forth, which sounds great, but it doesn't actually mandate that anybody look for lead. and all the time, brokers give buyers this form to sign where they basically waive their right to do an inspection. So the bill has not only not worked as it was intended, it almost works as a disincentive for people to test property, because once they test, they've now put a scarlet letter on their property because they know there's lead paint there. So what it would do among other things, it would ban those waivers, and it would require that there be a test one time, just once. It doesn't have to be done again, because there's not going to be any more lead coming into the property. A certificate that there was a test, an XRF test of the property before it's sold. And that would be required when the deed is recorded, and also sent to the health department, so we can start having a database of where the property is that has lead paint. I should mention, by the way, down here in New York City, we amended the law recently to require that all proper rental units be XRF tested within 1 year of a child under the age 6 moving in, or in all property by August of 2025. So in theory, in New York City, we're going to know where every property is that has some lead paint. It doesn't require necessarily you abate it, but we know where it is. The cost of this test, which is not that high, would be deductible from the real property transfer tax. It would mandate brokers to inform the parties to this obligation, and would also improve the existing property disclosure statement that's supposed to go with property sales to include information about lead paint and lead service lines. The status is it passed the assembly this session, this past spring, came out of the Judiciary Committee in the Senate, but didn't make it to a floor vote. So we kind of have to start over again in January. The next bill is the Renovation, Repair, and Painting bill. So federal law requires safe work practices and training for people who do work on homes that is not intended to be abatement, although it can be just the same work, right? I mean, it's very much an intent-based standard. If you hire someone who says, I'm coming in here to abate the lead paint, then they need to be EPA certified. But if they're saying, no, I'm just ripping out the wall, which happens to contain lead paint, it's not abatement, but it is nonetheless covered by federal law. The problem is, this is one of these EPA programs that actually allows states to take over enforcement if they wish, as long as they meet certain minimum standards. While some enlightened states like Alabama and Arkansas have taken this over, New York has not done so, even though we have the highest number of older housing dwellings with lead paint and the highest number of elevated blood lead cases. I brought this up for about the last 10 years at the Lead Advisory Council, and it goes nowhere. So, and the problem is EPA really does not have the resources to properly enforce this. That's what the Inspector General found. EPA has 3.5 inspectors to cover EPA Region 2, which is New York, New Jersey, Puerto Rico, and the Virgin Islands. So you can take a guess at how active their enforcement is. So this would allow New York to take over the RRP program, conduct the training and certification and enforcement. And in addition, the federal RRP program uses this concept of cleaning verification, which is not a dust wipe test which is the gold standard, right? Where you take a Swiffer and you wipe it across the area and you send it in the test tube and you actually get a number. What the federal RRP regs is this thing called cleaning verification, where not an independent person, the contractor themselves, who has a conflict of interest here, right? Wipes a cloth across the surface after it's been cleaned and compares the amount of whiteness on the cloth to this card. Okay, I never find this passes the giggle test with me. It's like, you ever go to a paint store and try to match the white paint in your bathroom to do a little repair? It's like, well, is that Snow White, Navajo white, whatever. So it would require that there have to be dust wipe clearance tests, which are not expensive. And the fees for accreditation of personnel would be used to fund the program. The Community Foundation in Buffalo did a great report on this, and they estimated it would protect about 140,000 children under the age of 6 each year in half a million homes that have some kind of this work annually. That bill is sitting in the labor committees of both the Assembly and the Senate. It was introduced pretty late in the session, so again, this will be work we need to do this coming year. The third bill is the insurance exclusion. Being lead sponsors are Senator Ryan and Assemblymember Rivera, both from the Buffalo area. And this would ban lead exclusion clauses in residential real property insurance policies. What do I mean by that? Well, almost all residential rental property insurance policies these days have a clause that says we do not cover injuries caused by lead exposure. The interesting thing is that back before the 90s, the State Insurance Commission didn't allow these, and the insurance companies tended to be far more far to the left of some of us on lead issues, because they were trying to lower their exposure to claims for this. So they were pushing for very strict policies on bringing rental property into a condition that's not going to poison the occupants. And then in the early 90s, Governor Cuomo the first, his commissioner, began to allow this, and the insurance companies basically left the field in terms of pushing to get better policies on lead control. So we think underwriting guidelines could help fill the gap caused by the lack of a statewide prevention law. Critically, the lack of insurance leaves injured children with no recourse against owners who lack resources. So you're just out of luck if you get poisoned. There's this image, I guess, that some people have that, you know, there are tons of cases out here that personal injury lawyers are just suing everybody left and right. And the reality is in many instances, they can't because there's no insurance to go against it and the property's not worth enough to pay anything. So this passed the Assembly. Easily, it's stuck in the Senate Labor, I'm sorry, that should say in the Senate Insurance Committee. And our understanding is Senator Breslin, who chairs that, is vigorously against it. So I'll just mention two other bills that are not that are kicking around. One is a school drinking water bill that's Senator Rivera and Assemblymember Gottfried. This tightens the level of water standards in school drinking water, mandates testing every 3 years, removes certain exemptions from testing, where right now, if under EPA guidelines, if a pipe is less than 0.25% lead, it's considered lead-free, and that would go away. Would require accessibility of lab reports and posting online, enhanced training of personnel, and remediation funding. And it passed both houses, and it's awaiting governor's action. And lastly, I'm going to mention a bill that there's been some push on by its main sponsor to get all of us to line up behind. And I have my own doubts about what it actually means. It's called Dakotas Law. And the idea is to basically put into state statute the requirements for screening that are already in state regulations. So I'm not sure what that does, other than it'll be state law now as opposed to state regulation. But it does nothing to change the lack of enforcement mechanisms for providers who aren't screening children. So I don't know what that does. It would expand the requirement of certification of testing to be presented for both pre-K and kindergarten. But one of the things that that bothers me is it says that healthcare providers would be required to advise parents, quote, of their right to an inspection if it's an area of high risk. I could be wrong about the law, although, you know, I have studied this stuff for a long time. But as far as I can tell, there is no right to an inspection. The court said that 45 years ago. So under state law, there is no such thing. So I'm not sure why a healthcare provider would be mandated to tell people that you have a right to an inspection. That's a false hope. It passed the Senate, and in the Assembly, it's in the Ways and Means Committee. So that's the end of my presentation. Hopefully I got through that in time. Sorry about the technical problems.